Hi, I'm Kenny. So far, we have learned that there are three forms of law in Canada immigration field. The LPA, including the LPR, the ministerial instruction, and the public policy. But what about a matter there is no explicit clause provisioning over? This is the first question I'm gonna try to answer in this video. And the other question is, we know that the visa officer has sole discretion when rendering the decisions to our applications. So is there a boundary to the visa officer's sole discretion? And if yes, where is the boundary? I will try to explain these two questions through a case study. And the story in this case is quite exciting. It involves Russian spies, the KGB, and the FBI. You don't want to miss it. Now let's start. As we all know, the law system in Canada is common law system, in which every case judged at the court becomes a part of the law itself. The jurisprudence reflected through this case law provides us the direction and the principle about how to interpret and apply the law into our practical cases. Among all these principles, making a reasonable decision is one of the most important requirements for the visa officer to conduct their sole discretion. In the following case, the law in question is not the LPA or the LPR, but the Citizenship Act and the regulations. And yes, the Citizenship Act and the regulations are also within the scope of we CIC's knowledge and business. So if you have any questions about the Canadian citizenship, you are welcome to ask me here. Let me first brief the happenings in this case. The PC's name is Mr. Vavilov. On June 3, 1994, he was born in Toronto as Alexander Foley. His parents were posing as Canadians under the fake names of Tracy Lee Ann Foley and Donald Howard Hisfield. Their real names are Yelena Vavilova and Andrei Bezrukov. They were working on a long-term assignment for the Russian Foreign Intelligence Service, the SVR, which is formerly known as the KGB. After Vavilov was born, the spy couple moved to France and then to the United States. They were leading an undercover life. They got a job, but of course it's not a diplomat. So they never enjoyed any diplomatic privilege or immunity. On June 27, 2010, the two spies were arrested by the FBI. Only until this day, Mr. Vavilov became aware of this. He and his old brother both thought they were Canadians. They were raised in Canada. They learned Canadian official languages. They were greatly shocked by the news that their parents are indeed Russian citizens. On July 8, 2010, the two spies pled guilty, admitted their status as Russian citizens, and they were acting on behalf of the Russian state. On the next day, they were returned to Russia in a spy swap. Just before their deportation, Mr. Vavilov and his brother left the United States on the trip that was planned before. They went to Paris first, and then to Russia on a tourist visa, and there they reunited with their parents. And due to the major change of their family, Mr. Vavilov probably stayed longer than the plan. And during this time, his Canadian passport expired. In October 2010, Mr. Vavilov tried to renew his Canadian passport through the Canadian Embassy in Moscow, and he failed. In December 2011, under the direction of Canadian passport authorities, he changed his family name from Foley to Vavilov and submitted to a DNA testing. His second attempt to obtain a Canadian passport failed again. He was told that despite his Canadian birth certificate, he would also need to obtain and provide a certificate of Canadian citizenship before he would be issued a passport. In October 2012, Mr. Vavilov applied for that certificate of citizenship, and it was issued to him on January 15, 2013. In the meantime, he also made another passport application through the Canadian Embassy in Buenos Aires, Argentina, and after a delay, he applied for a mandamus, and that was settled out of court. In June 2013, the IRCC agreed to issue a new travel document to him by July 19, 2013. However, instead of a new passport, he received a procedural fairness letter from the Canadian Registrar of Citizenship, dated July 18, 2013. The registrar stated that Mr. Vavilov had not been entitled to a certificate of citizenship. His Z certificate had been issued in error, and pursuant to the Citizenship Act, he was not a citizen of Canada. He was given an opportunity to make submissions in response, and he did so. On August 15, 2014, the registrar formally cancelled Mr. Vavilov's Canadian citizenship certificate, according to the citizenship regulations, for the following reasons. The number one is, although Mr. Vavilov was born in Toronto, neither his parents were a Canadian citizen or a permanent resident at the time of his birth. Secondly, the registrar believed that at the time of the birth, his parents were employees or representatives of a foreign government. And the third one is, therefore, Mr. Vavilov had never been a Canadian citizen and had not been entitled to receive that certificate. As we all know, any person born in Canada is automatically a Canadian citizen, but there are several exceptional cases. And the paragraph A of subsection 2 of section 3 of the Citizenship Act is one of them. In this exemption clause, there are two elements at the time of birth. The first one is neither of the parents was a Canadian citizen or lawfully admitted to Canada for permanent residence. And the second element is either of the parents were representative or employee in Canada of a foreign government. Mr. Vavilov applied and was granted a leave to bring an application for the judicial review of the registrar's decision in the federal court. His application was dismissed. Then he applied for an appeal in the Federal Court of Appeal. And in 2017, his appeal succeeded, and the registrar's decision was quashed. The IRCC then appealed this decision to the Supreme Court of Canada. There are several legal issues discussed by the judges at the court. I'll just talk about two of them here in this video. The first one is, was the registrar's decision to cancel Mr. Vavilov's certificate of citizenship reasonable? There is sufficient jurisprudence strongly supports the conclusion that the exemption clause was not intended to apply to children of foreign government representatives or employees who have not been granted diplomatic privileges and immunities, despite it doesn't explicitly say so. Because Mr. Vavilov's parents had never been granted diplomatic privileges and immunities, like a diplomat, and of course because they were undercover spies. This exemption clause cannot be applied to the parents. Therefore, it was not a reasonable decision to cancel Mr. Vavilov's citizenship certificate pursuant to this exemption clause. The appeal was dismissed, and the registrar's cancellation was quashed. Mr. Vavilov's application for the citizenship certificate was sent back to another registrar for a redetermination. The registrar's decision was unreasonable. So what is a reasonable decision? In this case, the judges confirmed that a reasonable decision is one that is based on an internally coherent and rational chain of analysis, and that is justified in relation to the facts and law that constrain the decision maker, which is to say there are four elements for a decision to be a reasonable decision. The first one is it has to have an internally coherent and rational chain of analysis. And the second is it must be justified in relation to the facts in the case. And the third one is it must be justified in relation to the law in the case. And the fourth element is that the fact and the law constraints that bear on the decision. Combining the third and the fourth elements, it's not difficult to infer that the decisions must be based on the law for the visa officers to make a reasonable decision. And indeed, this is one of the core requirements for the duty of procedural fairness. Besides, this decision must be based on the law. Is there any other requirement for the duty of procedural fairness? The answer is yes, and I'm gonna talk about them in the following videos. So stay tuned. I'm Kenny. Learn my lessons on your way to Canada. See you in next video.